We will have now a talk from Professor Gerd Knoops and Mrs. Carrie Knoops Hamburger. We'll talk about navigating legal procedures in wrongful conviction. Professor Dr. Knoops is a lawyer at Knoops Advocaten or attorneys and also acts as lead counsel for the International Criminal Court in The Hague. He is also a professor by special appointment in the politics of international law at the University of Amsterdam and a visiting professor of international criminal law at Shandong University in China. He also wrote several books in the field of national and international law, and furthermore, he is vice president of the European Innocence Network. Mrs. Carrie Knoops Hamburger is director and managing partner of Knoops Advocaten or attorneys, and she is on the list of lawyers allowed to act at the International Criminal Court in The Hague. She is the director of the Knoops Innocence Project, chair of the Miles for Justice Foundation, and chair of the membership committee of the European Innocence Network. So together with Professor Knoops, she has given lectures at the University of Amsterdam, and they also published a joint book in 2022. And until today, the Knoops Innocence Project has helped 7 innocent individuals to reopen their cases and to get exonerated in the Netherlands. And we are very pleased that you have agreed to speak here today. So please, the floor is yours.
Yeah. Good afternoon. Thank you so much, Ms. Schneider, for your kind introduction. I congratulate the founding fathers and ladies for the launch of this very extraordinary exoneration register in Europe. And I've been informed by Ms. Linda Gaven that's already, I think, 113 cases have been registered in Europe of wrongful convictions, amounting to, I believe, 800 years wrongful imprisonment. So that's quite an impressive figure, and that's what we also can use in the Netherlands to hopefully persuade also our politicians that the innocence movement should be put on the political agenda of our government, which until so far has not been recognized. Our Innocence Project, which was established in 2011 in connection with the American Innocence Network, was never officially recognized by our government and was never funded by our government. So I hope with this exoneration register, it makes clear that as opposed to our Minister of Justice in the Parliament in 2005 said that wrongful conviction in the Netherlands are unique phenomena. It's just on an occasion that such a miscarriage of justice might happen in our law system. And now I think we have objective proof that we're not dealing just with incidents, but unfortunately, wrongful convictions, even in our law system, which is supposed to be one of the top 5 in Europe, is even vulnerable for wrongful convictions. In our own Innocence Project, the Knoops Innocence Project, which was already established before 2011, when we acceded to the American Innocence Network, we were able the last 20 years to reopen in total 7 high-profile criminal cases, which amounted to acquittal of 7 wrongfully convicted persons, in total 39 years and 10 months. This is the statistic of our law firm. So mind you, what could happen if this movement in the Netherlands could be expanded. Now, currently we're working on 3 other high-profile criminal cases. One which led to a life imprisonment of a Rwandese convicted person for being implicit in genocide in the Netherlands. Well, in Rwanda, but he is detained and convicted in the Netherlands. And it's also clear that wrongful convictions can also occur on a level of international crimes, which is almost for, I think, the population unthinkable, but it can happen. And we are now working with the Attorney General to have that case also reopened. One of the major problems we face, and Mrs. Knoops will take over after my short introduction, actually are 2 important things, and that's why I think the exoneration register will also help our project in obtaining more recognitions, like in the United States, where the innocence movement is already recognized also as a societal movement, is the fact of the funding, the absence of funding by the government to sustain forensic investigation in order to have cases reopened. The burden of proof rests on the convicted person in our system. Even when you ask for a preliminary inquiry by the Attorney General in the Netherlands at the Supreme Court, which is possible since 2012 when the law was adapted in the Netherlands, still the convicted person has to present an objective indication that there might be a new fact, a new piece of evidence to justify the reopening of his case. And that means that also with this preliminary investigation, the convicted person has to present that evidence. And that means that he has to finance that piece of forensic investigation. This is one of the major problems. The second problem is, of course, the burden of proof, which in our system is very high. It's almost equal to a proof of actual innocence. The high threshold our Supreme Court has set in recent cases reinforces actually this whole perception. In our system, all requests for reopening of criminal cases has to be filed directly to the Supreme Court. In the United States, the trial judge who has referred the case to the jury is competent in ordering a hearing for a potential retrial. In our system, all those cases go to the Supreme Court, and the Supreme Court actually puts itself in a position, what would the Court of Appeal have done if the Court of Appeal would have been confronted with this new piece of evidence? And that means that the threshold, therefore, at the Supreme Court is very high. This is something we also try to amend with our cases, that the Supreme Court should be conscious that it's almost impossible to bring actual evidence of innocence to the court. Last element, and that's the reason why we set up, Carrie and I, with Professor Luca Luparia of the University of Rome and Milano, and Professor Mark Gozzi of the Ohio Innocence Project, great people. In 2000, I think it was 17, we set up the European Innocence Network. That's actually a parallel with the American Innocence Network, meant to actually set up a network in Europe where all the innocence projects in all the European countries will work together. Annually, we have a conference. The last conference was in Amsterdam. We have had conferences in Barcelona, in Milano, and we share experience. We share also knowledge. We share also experts. And one of our latest projects is, and that will be launched in March in Geneva, and most likely also the end of March in, I think, New Orleans, is we are working with a group of experts in Geneva to have the UN adopted a UN resolution on the right to innocence. The right to innocence is not a human right in one of the international human rights treaties. You would say, well, it's obvious that there is a right to innocence, but it's not. If I tell you that in our cases, we are confronted regularly with the situation that forensic evidence has been destroyed by the state, despite the fact that in a homicide case, there's always a reason to re-examine the case once the defendant claims to be innocent, that the right to innocence as a human right should be accepted by the United Nations as part of the human rights catalog. And the derivative rights should be, amongst others, that all the evidence which has been gathered by the prosecution, biological evidence, other evidence in for instance, a gun or clothing which were subjected to DNA evidence, should be preserved until the convicted person agrees that it should be destroyed. That's one of the main federal rules in the review proceedings in the United States, very importantly. And of course, the right to innocence also implies that once innocence has been established, that there is a right not only for retrial, but also for financial compensation and for rehabilitation. There is no rule in our system which governs this form of rehabilitation. We have done cases in the Dutch Caribbean where 2 people were exonerated in 2013 for double murder they didn't commit. And one of the main former defendants was in prison for almost, I think, 12 years. It's Ms. Gaven will probably recognize the case, the Spelonk case, the famous Spelonk case on which we wrote this book you mentioned, Ms. Schneider, in 2017, whereby the former defendant was released from prison without any social structure, nothing. And our Innocence Project helped him with a social worker, helped him with finances, helped him with finding a job, etc. So that means that the right to innocence encompasses more than just having the possibility to file to the Supreme Court to have your case reopened. It implies far more. And we hope in March, we have a meeting with the United Nations Human Rights Committee, with our group of people of the Innocence Network in Europe and the United States, that we can get the support of the United Nations Human Rights Committee for such a resolution. That resolution will also resonate, of course, in other European countries, and it might help also to have the Innocence Project in Europe being recognized, because wherever you look in Europe, there's no government in Europe who recognizes the Innocence Project as legitimate organizations which deserve support from the government. Financially support. It's not for the lawyers' fees, because we do this work pro bono, but it's far and foremost for the expertise, the forensic expertise, investigation. Like the case we did in Bonaire, the Spelonk case, we retained several experts, and everyone knows that the price, the reimbursement of experts is quite considerable. Somebody who has already spent 7 or 8 years or 9 years in prison has not the finance or the means to finance these expensive forensic investigations. The average duration of an investigation in our project is between 5 and 6 years before we even can bring a case to either the Attorney General for such a preliminary investigation or directly to the Supreme Court. And that gives you a short impression on all the obstacles we are confronting. Mrs. Knoops on my right side, she went 3 times to one of the ministers of justice.
7 times.
7 times. So you can also make a calculation on our age.
And each time the minister said, well, you know, what you guys do is fantastic. We really appreciate it, but we will not give you a fund. No money. There is no money for such a fund.
No.
So whatever we say, whatever we explain, we get approximately 50 requests per year. It used to be more, but as the Supreme Court is denying most of the cases presented to them, a few people just don't believe anymore in a retrial. So from 80 to 100 per year, we are now back to approximately 50 to 40 requests a year. And most of these people do not have enough money, cannot pay for the expertise. Ever so now and then, we try to provide finances from our own office, from our own income, but we can't pay for 50 to 80 cases. It's too much. So whenever I go to one of the ministers of justice, I explain this and I say, wouldn't it be fair if, in case your government, the Office of the Prosecution is part of the government, if you make a mistake, in the end, we realize you made a mistake, shouldn't you then not help and finance some of the investigations? Now, Professor Knoops explained that sometimes we can ask the chief prosecutor to assist us. There is a commission, it's called ACAS, that helps investigate. But before you ask such an organization to assist, you have already, you need already some proof of innocence. Otherwise, you just can't go there and say, our client says he is innocent. It's not enough. So even if you go to get an assistance from the ACAS, you need to have something to provide in order to prove them that your case might be relevant. So whatever we say to the government, so far, they don't set up a fund for assisting all these people. So the few we were able to help, most of them with the help of our own finances, it doesn't provide you a proper view of all the innocence cases that exist in the Netherlands. We have had a colleague, very intelligent colleague, who assisted us in one of these cases that is now pending in the Caribbean from Belgium. She did an extensive research on innocence projects in Belgium. She came back to us and said, none. I don't know if your organization have found some or one maybe or more, but Belgium, it just doesn't work there. So with us, she is going to try to set up an innocence project, but for her, it's even more difficult. So the 7 people we were able to exonerate between 2001 and today, and we have many cases now where we're working on, and 3 of them are pending at the Supreme Court. It for sure. We assume that there are many more, although we can't say that our prosecution doesn't work properly. That's not it. I'm sure at least 70-75% is well done. But we consider that there are many more wrongly convicted than that we can prove now.
I would like to close, Ms. Schneider, in light of the time, with 3 brief remarks. I think very important also for the relevance of the innocence network, but also of the acceleration register set up by Ms. Gaven and Ms.
That might help.
Drijbusch, I think. No?
No.
Oh, sorry. Yeah, Strijbos. Anyway, the 3 founding ladies of the European Acceleration Register and compliments for this initiative is very good. I'll explain you why it's so relevant that we have this register. First of all, every time when we speak with the government, with the ministers about the relevance of funding of innocence work, we hear, and it's even in the evaluation reports of the government every 5 years, on how the law on revision exists and functions in the Netherlands, we hear, Mr. and Mrs. Knoops, look at the statistics. It's not too bad in the Netherlands. We have only 30 applications a year to the ACAS, the commission who advises Attorney General on the reopening of cases. Since 2012, we have this commission. It's okay, it's fine. We don't need any reform of the innocence work. We say, you know why the statistics are so flawed you rely on? That's because, first of all, there is nobody in the Netherlands without funding who can go to the Supreme Court. It's discouraging that if we say to a client, you have a case for potential reopening, but there is no funding, we cannot pay the experts. The result is that that case is not going to the Commission or the Supreme Court. So the statistics the government is relying on are very subjective and are not objective for the overall average of potential wrongful convictions in the Netherlands, first of all. Secondly, if we look at the figures internationally, and we mentioned already the work in December of last year by the European Acceleration Register, 113 objective cases being determined. If you look at the work of the Innocence Project in the United States, our colleagues starting in 1889 by Barry Scheck and Peter Neufeld, our colleagues in New York, by the way, they have a project where 100 people working there full-time, sponsored partially by the federal government and private sponsored. 100 people working in New York only on innocence work. The National Registration Register in the United States establishes that 175 wrongful convictions have now been determined every year in the United States. Last year, 3 people on death row and 8 persons life imprisonment. That are the statistics. If you make that work serious, I'm sure even in Europe, we will detect more wrongful convictions, as Carrie said. And that's very important why the European Acceleration Register is launched today. Lastly, the main issue we are confronted with is awareness. Awareness, acceptance that miscarriage of justice can exist. In the United States, as I mentioned in the introduction, the society, including the judiciary and the prosecution service, are well aware that wrongful convictions are part and parcel of a legal system. In the United States, a few years, the phenomenon of conviction integrity units has been established, CIUs, where prosecution and defense, hand in hand, investigate together, share knowledge to determine whether a conviction has to be overturned or not. We experienced this once in 2012 in Bonaire, in the Dutch Caribbean, where we worked 2 months with the prosecution service to reconstruct a double homicide. And we were able to find the real perpetrator. And as a result, the 2 convicted persons were exonerated. That example, that blueprint should also be applied here in the Netherlands. And therefore, I think, and that's my last remark, the European Acceleration Register will hopefully bring also awareness to the governments in Europe that innocence work is important. We have an obligation to our society, to those people who are wrongfully convicted, to do this work, and we cannot do it on ourselves. We need people like you to assist, and we need the government. This is, in short, how we work here and how we perceive the launch of this extraordinary event today. We thank you very much for your time and wish you all the best with the future I would say endeavors. And I asked Ms. Gaven to keep us updated on the new figures, which we can use for our negotiations with the government.
Yeah, sure.
And it's wonderful to see now live on screen.
Mr.
Professor Cassin.
Hi.
We have used one of your presentations in the Caribbean.
Oh, that's a beautiful anecdote.
Wonderful.
On the screen.
You have done such great work in terms of false bekentenissen?
False confessions.
False confessions.
And you know, Professor Cassin, we exchanged thoughts last year on a case in the Netherlands. Ms. Gaven knows the Arnhemse Villa-moord.
Yes.
And we have very much used your eloquent analysis of that case. And we're still working on it, by the way.
Oh, wow.
Yeah, we're still working on it. I hope you will be one time you come to the Netherlands to lecture our judiciary.
I would love to meet. I would love to meet in person.
Wonderful. Thank you very much. And thank you that we were allowed to say a few words.
And I'm also happy to see Miss Amanda Knox again in Freedom for several years. We worked together with Luca Luparia, one of your counsel in Italy. He's the president of the Innocence Network, and I'm the vice president. Carrie is also in the board of directors. And maybe we see you at the next convention of our project.
I would love that.
That would be wonderful. Bye. Bye-bye. And good luck.
Thank you so much.
Bye.